We welcome each and every one of you. We'd like to ask you to keep yourself on mute. That's a little bit of our housekeeping. Here we are discussing everything from estate planning to how to avoid appropriate administration and everything in between. And today we're actually talking about spouse disinheritance. Oh my. All right. So without further ado, let me introduce to you Samantha Fitzgerald. Samantha is an attorney in plantation, and her firm is 100% focused on estate planning and probate and trust administration. She has been practicing for over 20 years, and she's a CPA and has an LLM in tax. Let's all welcome Samantha Fitzgerald.
Hi, everyone. Thanks for joining us today. This should be really fun and interesting.
Very interesting. And my name is Bianca Moraris, and I will be your host and moderator. And I am a business consultant and coach. I have over 20 years in my own business, but 36 years working with the legal industry. And I love helping attorneys be successful and more successful than what they've already have attained in their life. So without further ado, we're going to get started. All right, Samantha, are you ready for this one?
I'm ready.
It's a hot topic, you can see by the audience. So here we go. Let's talk about this. Disinheritance. Can my spouse disinherit me?
Well, not really. So one of the largest spousal rights that someone has, aside from the primary residence, is something called elective share. So you can set up your will or your trust and say that you're leaving everything to your girlfriend or boyfriend or to your children or whomever. But your spouse still has a right to make what's called the elective share, which is a really complicated analysis and calculation, but effectively it's 30% of everything that you own. And that really includes a lot of different stuff, even things you own jointly with somebody else, certain portions of life insurance, your retirement accounts. It includes a lot of almost everything. There's like some exceptions, but for the most part, they can still get 30% of what you own. Now, the kicker here is that it's not something that happens automatically. It's something that the surviving spouse has to elect in a probate administration. So if the deceased spouse, if none of their assets had to go through the probate process, the surviving spouse would have to open the probate administration in court and make this election. And then they go through a very complicated analysis and calculation of what's included in there. There's a way to make it better, less of a hit. So if we think, as we're doing planning for a client, if we think that, if they're not leaving enough to their spouse in their documents, and we think that there's this possibility of the spouse making an elective share, we can include provisions in their trust agreement for what's called an elective share trust, so that the spouse can't just take 30% of everything and walk away with it and give it to whomever they want to give it to when they die or while they're alive. In the elective share trust, it stays in trust and only certain portions of it will go out to the spouse. And then whatever's left in that trust when the surviving spouse dies will then go back wherever our client or the initial deceased spouse would want it to go, usually back to their kids or something else. So that's really important to include in your documents. I don't really see it a lot in other documents that we're reviewing. But it is really important, and it's an option to include in there.
Wow. It sounds complicated. I'm glad you know about it and can teach us this. So let's talk about prenups. Are prenups valid in Florida?
Absolutely. They have to be done right. Some states, I think, don't allow them or don't really favor them, but in Florida, they're perfectly valid. Things that you don't want to do when doing a prenup, assuming you want the prenup to be effective, which maybe you're on the other side and you don't want it to be effective, but if you want it to be effective, then don't sign one the day before your marriage or anywhere near your marriage. Leave plenty of time in between. Each spouse should have their own lawyer. So this is one point that's really overlooked, or intentionally overlooked, because they don't want to spend the money on having two lawyers. But if you're the one that wants to make sure that the prenup is enforced, you better bet your spouse needs their own lawyer. I'm not saying 100% of prenups that don't have separate counsel are going to fail, but it's one more factor that is going to play into the potential failure of it. Make sure they're not coerced into doing it. Make sure it's under the circumstances fair, and that everything's disclosed. All assets must be disclosed. So technically the rules don't require them to be disclosed prior to a marriage, but you're just setting yourself up for failure if you're not going to adequately disclose. And make sure, this sounds so silly, but I have seen fully executed prenups that are not fully filled in. So like the witness names might not be there. Maybe the dates aren't filled in. Not only is this exceptionally sloppy work, but again, you're just opening up the door for your spouse to try to contest something. So, and if you move states after you have an executed agreement, I highly recommend that you have the agreement reviewed under that state's law. We've seen agreements here that were executed outside of Florida, and we have some funky rules regarding homestead here that were not addressed in this particular prenup that I was reviewing. And that definitely would have been a problem here.
Oh, wow. So not before married, and everybody needs their own attorney. I think that's really good advice. I need to tell my friend who's getting married soon. So if someone is married recently, and they each own a house in their individual names, they're currently living together, and they're in this house, and it's only titled in the husband's name. What will happen if he dies?
So this is an interesting outcome. As I alluded to before, homestead is one of our quirky little rules that we have in Florida. Quirky for the spouse and quirky for children as well. But so in that scenario, you have a couple living together in their primary residence. That's the homestead for the most part, your primary residence. So there's rules. So you have to, your spouse has, that's the other big right. Besides elective share, the homestead is the other huge right that spouses have. So if the husband had died, his wife automatically gets a life estate in that property. If there's children, regardless of who the children are, the spouse automatically gets a life estate in that property. She does not need to be on the title. It doesn't matter if the property was owned before the marriage or after the marriage, the spouse automatically gets a life estate, meaning that they get to live there for the rest of their lives, or they get to control the property for the rest of their lives. If they move out, they can rent the property. The next level has no say-so over anything, really. I mean, there's always exceptions to stuff. But the spouse gets to control or live in that property for the rest of their life, if there are children. Now, the big difference between that and the elective share is that the life estate happens automatically. There's nothing that the spouse needs to do, nor can do. Once the spouse dies, that's it. That automatically passes to the surviving spouse. Instead of the life estate, it's not really that new anymore. It's been around for many years. They can make an election to take a 50% interest in the property instead of the life estate. So that means the kids get the other 50% and the spouse gets the 50%. So they're co-owners of the property. That is almost always recommended to do, and that does have somewhat of a short time frame of 6 months from the date of death. So that's really important because a lot of deadlines revolve around some sort of notification, but that deadline is a very strict deadline, 6 months from date of death. And the real benefit of having that is that either side, whether it's the spouse or the children, can force the property to be sold. So that's huge, because with a life estate, neither side can really do much of anything to the other side. Now, if there are no children of the deceased spouse, the surviving spouse just gets the property. It's 100% to them. It does have to go through the probate process, but it passes 100% to them.
Samantha, I have a
Now,
question.
hold on, let me go back though. So the other property, so that's the primary residence. So the spouse, whether it's the deceased or the surviving spouse, they own a different property. It's not their primary residence. Well, that's just like any regular old property. The surviving spouse doesn't get any special interest in that property, but it is part of the elective share, the elective estate that I mentioned earlier. So a real quick example of something that I've seen happen. Man and women get married. The husband sells his home, gifts all the money to his children while he's alive. The wife, they move into the wife's property. Now that's their homestead. Marriage is rocky. She doesn't want to leave that home to her husband. She's stuck. He was able to do whatever he wanted to do with the proceeds of his property, but she is stuck leaving him this property that they live in because it's homestead. So that becomes a very unfair result under those circumstances. So it's really, really important that people understand the significance of our homestead rules here.
So I have a question for that, and there is a question in the chat. If someone gets married and they own the home before they got married, but it's the homestead and now they're married and that person moves in, the rule that you're talking about applies?
Absolutely. And a lot of people don't understand this. I've had many, many meetings with clients that are really shocked about this. They say, but I've owned this property. They may have owned it for 30 years. It may have been handed down to them for generations. And then they get married, second marriage, they have children from prior relationships, and they don't understand why the spouse now all of a sudden has a right to it. Not only do they have a right at death, but they have rights while you're alive. So you can't sell the property, you can't mortgage the property, you can't do anything without your spouse's consent for your homestead. It's very restrictive and kind of quirky, as I said. It does not matter when it was acquired. So you could be married for 5 minutes and all of a sudden this person has rights to this property, which is very problematic for some people, especially, if they don't have a good marriage, and, causes a lot of problems.
Wow.
Now, and there's a huge difference between death and divorce. And I'm not a family lawyer, but that is a huge distinction. Pre-marital assets versus marital assets. There's no such thing in the land of death.
Oh gosh. So the question that's in the chat says, does an ex-spouse have any rights to anything?
No.
Okay, good. So divorce solves that problem.
Yeah.
Okay, cool.
Yeah. Once you get divorced, they are treated for pretty much all purposes as if they died, which, some people may enjoy that, but
that was quite funny,
so,
dear.
yeah. So they're automatically cut out, which is helpful, because sometimes people aren't thinking of redoing their documents when they're going through a traumatic experience like a divorce. It's actually more important to update your documents during the divorce proceedings, because you're still married. Once the divorce is final, you're okay. But while you're in the bad marriage, or going through the divorce proceeding, you really should update your documents, because your spouse has a lot of rights still.
Whew, wow, makes your head spin. So if you're in a second marriage, and let's say you each have children, and prior to that marriage, you want to leave, well, while you're in that marriage, you want to leave what you own to your children. Can you do that? It sounds like you kind of hit on that, but I'm not clear.
Yeah, so it's a problem. I see this a lot. People come in and they say, "Oh, this is what we've agreed to." And it's like, "Okay, that's great. You've agreed to that, but that's not what happens under Florida law." So homestead is the biggest problem because it's an automatic thing. Elective share is something that they have to actively elect. So if they don't go to court and elect it, you're okay. But there are ways to waive these things. So if you do have a pre or a postnuptial agreement, these are typically things that are waived in those agreements, standard. But if you don't go to the trouble of having a full-blown pre or postnuptial agreement, then there are shortened versions of this. I call it waiving the death rights, where you can just waive the homestead, elective share, and the other smaller rights that you have. Similar issues, where you really should have separate lawyers reviewing them. You may waive those rights in exchange for something. Maybe you're going to let me live in this property for however long. In exchange, I will give up my homestead rights. Because coincidentally, you cannot, even though a spouse may get a life estate in the property, it's not okay for you to leave them a life estate, which is weird. So that's an invalid devise, and then it would revert back to a life estate, which is weird, but it messes up your estate plan. If you're having certain provisions in your will or your trust, you don't want to do it wrong. So you do have to get the spouse to waive those rights in writing. They have to understand what they're waiving. And not only can it be done in like a separate document waiving all of those death rights, you can actually now, which is a fairly new rule, a couple of years now, you can waive just your right to homestead directly in the deed. And that is really handy. Still, you want to make sure that the spouse understands what they're waiving and maybe have them go consult with another lawyer. But it's a really easy way to be able to waive that very, very big right that spouses have.
Wow. So many different avenues to get to one conclusion. So, wow. Thank God you're the smarty in the room. I love that. So if someone was recently married and they already have a will, let's say the wife has a will, is there anything further that needs to be done? Is that, the wife saying, I don't need an estate plan. I don't need anything else. Is that true?
No, you definitely need to update your documents if you have them in place and then get married. The spouse or a child that's born after documents are created are called pretermitted spouse or a pretermitted child. And what they end up getting is what they would normally get under Florida law if you had no will. So that's what we call an intestate share. So the spouse would get that, and then the rest of your will controls the disposition of your other assets. That's not a good result, but the bigger downside to that is that it only covers probate assets, which could be zero or could be very little compared to a decedent's overall estate. So it's really not ideal in any way. If you have documents in place, it's really important that you quickly update them if you're getting married. You can do it before you get married as well, and that would apply. So if you are doing documents in contemplation of getting married, that's okay as well. But definitely don't just leave your old documents out there. I had a case where that happened. They were married for 10 years. The husband never updated his documents, and it was a mess. A big mess. There was an ex-wife, there were children from a prior marriage. It's just a mess and very sad and heartbreaking because, my client her heart was broken that her husband didn't care enough about, updating these things, and that his ex-wife ended up inheriting assets, and it was a big mess.
Oh my gosh, that's terrible. So let's talk about another topic. If you're not legally married, but you've been living together with someone 10, 15 years, are you considered a common law wife?
No. People come into our office all the time and they don't even ask. They just say it matter of factly that they have some sort of rights because of the common law. And I don't know where they get this from. Obviously Google somewhere, but this is very state specific, and Florida does not recognize common law marriage. So it doesn't matter how long you've been living with somebody, you have zero rights if you're not married.
Oh my.
Now, if they name you as a beneficiary on something, or you own assets jointly with that person, you know, you may have a right to the property, but you have no spousal rights.
Oh boy. Well, what about things like in general, you know, your car, 401k? I mean, you wouldn't have any rights to any of those things.
No, and those are all like interesting kind of assets. So cars are the one asset that can be transferred outside of the probate process. They are also considered what's called an exempt asset. So there's a couple of smaller things that are exempt and pass under our statutes to the surviving spouse. So these are kind of like the lesser known things. Homestead, elective share are the big rights, but the smaller rights are 2 vehicles that are regularly used by the decedent, household furniture and furnishings. Under our statutes, it's 20,000, and under our constitution, it's 1,000. So it's 21,000 technically, and college plans. So that's kind of twofold. All of those things not only pass to the spouse, but they're also exempt from creditor claims. So you get a twofer there, unless they are specifically devised to somebody in the documents, in which case they are still exempt, but they wouldn't pass to the spouse then. I had that happen in a case with a pre-terminated spouse, which was interesting. And the car was specifically devised to the child. So that passed to him instead of the spouse. 401ks are an interesting thing as well. You have to leave them to your spouse. So if you try to update your beneficiary designation on those while you are married, it's invalid and it will pass to your spouse anyway. If you want to make any changes, you know, to those things, your spouse has to sign off on it. I'm not a 401k expert, but I'm pretty sure that as long as the designation is there prior to the marriage, it will go to the other beneficiary and not the spouse. And interestingly enough, IRAs don't have the same rules. So 401ks are governed under ERISA, which is a federal law. IRAs are not governed under ERISA, and you can name whomever you want on an IRA. So an interesting strategy, if you knew you didn't want to leave this to a spouse, might be if you could dissolve your 401k, you know, like roll it out of the 401k plan. Maybe you don't work for that company anymore. You could roll it into an IRA and then have a lot more freedom and flexibility over it. And a lot of times that's somebody's largest asset. You know, they worked for a long time and have socked away a lot of money in there. So it can become very problematic.
That sounds very interesting. What a great strategy. And what, like, can you let's give us some information, difference, divorce, remarriage? What kind of stipulations fall into those categories?
Yeah, you have to be really careful of divorce and remarriage, and just make sure that everything's working the way it's supposed to work. We had a little kind of hole in our statute that was recently fixed. Earlier, we spoke about if you have documents and then you divorce, you know, your spouse is automatically cut out of those documents. The way our statute read before, there was a little bit of a loophole depending on when you got married. So that's been fixed. So that's okay. It covers all of the scenarios, but you still should check, you know, you want to make sure that your beneficiary designations are all correct. You may be accidentally disinheriting your spouse when you don't want to. You may be accidentally leaving something to your spouse that you don't want to. So whenever there's a change up in your marital status, it's really important to speak with your lawyer and verify that everything's okay, or if something needs to be changed. Some smaller things too that spouses are entitled to. Something is called a family allowance. You don't see this all that much, but if you're ever in need of it, you should know it's there. You can get up to $18,000 during a probate administration if this decedent spouse was supporting the spouse or children. So it's a small amount of money in the big scheme of things, but it is something that you can ask the court for. It's kind of a weird rule because it doesn't say you get $18,000. It says up to. So you have to ask for it. It could be lump sum. It could be paid over time. It's really going to depend upon the assets in the estate. But that's also exempt from creditors. So that's something that you might want to use as a strategy. If the estate has creditors, you may want to ask for this family allowance just to keep it away from the creditors. Another interesting point is if you are an illegal alien spouse, it doesn't matter. You're still entitled to these rights. So that's kind of important to know. Some of these things, though, do depend on the residency status of the deceased spouse. So, you may have a probate administration in Florida, or there may be a trust administration in Florida because there are assets here. But if the decedent didn't reside here, then a lot of these laws don't apply to the spousal rights. There still may be a probate administration, but the surviving spouse may not have any rights because it's not what we call a domiciliary estate here. So that's kind of important to know. It's going to be, some other state's law that applies, and it's very different from state to state, the probate rules.
Wow. Okay. Well, I am glad we have you here in sunny Florida with us and that you can help each and every one of us. Does anyone have any questions? You're willing to raise your hand or throw something in the chat, something that you need clarity on. In the meantime, while you're deciding that, please take the time to call Samantha's office. Her office is so well versed. This is all they do, 100%. They work as a team. They also have Spanish speaking, so we're able to help many of you. And we are just so excited to answer any of your questions. Just feel free to reach out. And if you don't have a plan, it's time to plan. Right, Samantha?
Absolutely. Everybody
Okay.
needs something.
Yes, everyone needs something, or at least to have the discussion, in a consult. So please take the time to do that. Any questions? No, I wanted to let you know that you can look on Samantha Fitzgerald's website and you will see 2 years. This is our 2-year anniversary this month of webcasting. And we would love for you to go and look at the different topics and get some education before you take a leap of faith, because Samantha is so well versed in also LLM tax, and she has a CPA degree. You are getting the finest and the best consult you could possibly get. She covers all your bases, and she's really funny. So you can have a really good time with her. She is really amazing. She's my attorney as well. So without further ado, would you like to say some last words, Samantha?
Thanks, everybody, for attending. I hope you learned something. If anybody has any follow-up questions, feel free to reach out to us. We're happy to answer them. And this is our last Zoominar of the year. So we're taking a break for the holidays. We'll be back in January. So hope you enjoyed it. Feel free to check out our other ones. If you have any topics you would like to hear about, feel free to email or text us those topics and we will take a look at them. And have a wonderful weekend.
Yes. Thank you, everyone. Have a wonderful weekend. Enjoy the holidays. It's right upon us. And take the time to make sure that your assets are secure. Bye for now, everybody.
Bye. Thanks, Bianca.
You're welcome.